Hello, this is Matt on the Moon Family Sedan channel. I want to share with you what Attorney John Deaton says the SEC's strongest argument in the SEC v. Ripple case is, and then we can absolutely crush it. I got a number of things to say on this. I also have some stuff from Attorney Jeremy Hogan in this latest Moon Family Sedan tepid jam. You can see here's a headline from you today. SEC v. Ripple. This is SEC's strongest argument about XRP, says crypto lawyer, and it stems from the most recent legal filing from the SEC. Shout out and credit to James K. Filan for sharing this one. And a lot of it was the SEC. They do make arguments pertaining to Howie, and I'll get into it, but a lot of it has to do with which redactions on certain personal information the SEC is okay with and which redactions they earn. A lot of it has to do with all sorts of finance information, including the fact that, let me tell you here at the outset of the video, one of the things the SEC wants to make sure that you listening to this are able to see is Brad Garlinghouse's compensation, including how much XRP he was given as part of his job. That's what they want out there. So now they want as much transparency as possible, but when it comes to anything else, especially the Hinman emails, not so much. Of course, because they're a bunch of asshat pricks. But before going any further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so there is a couple tweets by XRP community member JV, and I'm going to read them to you in just a sec. They're on your screen here. In the first tweet, he's noting what might help the SEC the most, harm Ripple the most, having to do with basically just Ripple's actual XRP sales and the fact that it was a very substantial, and this is true, a very substantial portion of how their business has been funded. And so this is the part that you'll see in a second. Attorney John Deaton says is effectively the SEC's strongest argument. But even though it's the strongest argument, it doesn't mean it can't easily be crushed, because the SEC says a bunch of complete and utter nonsense. But anyways, here's a XRP community member, JV. He shared a clip from somebody who made a video actually covering this same content from attorney James K. Filan, the SEC filing. So JV wrote, "This is what's going to hurt Ripple and will probably convince the judge that Ripple's XRP sales are unregistered security transactions. Where that leaves secondary holders in the judge's eyes, I don't know. If she feels that Ripple's entire distribution method of XRP was to ultimately fund themselves, keep their business afloat, and fund partnerships, then she may even deem secondary XRP to be securities. Worst case scenario for us retail holders." Okay, well, look, if Judge Torres finds Ripple sales of XRP from some point in time and moving forward from that point in time forward, if the Judge Torres finds that those sales from a certain point in time and moving forward are not illegal unregistered securities transactions, then there would be no reason to think that transactions on secondary markets, people like you and me buying and selling, no reason to think that would constitute unregistered securities transactions. There wouldn't be any additional clarity needed for regular XRP holders in such a scenario, so far as I can see anyway. However, if all of Ripple's transactions to this point in time and moving forward are found to be illegal unregistered securities transactions, then XRP holders in the United States, like myself and many of you listening, will be left in an uncertain and precarious situation. In that case, additional clarity would be needed at that point. But can Judge Torres, even if she thinks that the SEC has some slam dunk arguments here, can Judge Torres have any impact on secondary market sales? Well, it turns out the answer, according to Attorney Hogan, is no, which is why I just shared first what I shared with you. Because again, if for Ripple, certain sales from a certain point of time and moving forward are not illegal securities transactions, then there's no reason to think that you and I would be conducting in anything illegal either. So we would get that clarity we needed. That's the only way that I'm aware of in which Judge Torres can have an effect basically on secondary market sales since she can't actually rule explicitly on secondary market sales. And the reason that I'm stating that she can't explicitly have any sort of ruling over secondary market sales, well, look at this tweet from attorney Jeremy Hogan from January 2nd of this year. He wrote in part, "I just don't see how Torres has any jurisdiction over secondary sales. She could put in something about them in dicta, but it wouldn't be binding." And so look, again, that's why, to be super duper clear, if Ripple, if all of their sales, so not just some early in the early years, but if all sales up to this point and moving forward would be securities violations, then we're screwed temporarily as XRP holders at that point in time. You know, there'd be appeals and this and that. Doesn't mean that the game would be over. But that's why, if we get some sort of clarity that from a certain point in time, for whatever the reason is, from Judge Torres' perspective, that Ripple's no longer, you know, breaking the law, then we sure as hell can't if Ripple isn't. It wouldn't be part of a scheme or anything of that sort. She does have power over that. She just can't explicitly decree anything just over secondary sales. So I hope you can see how I was parsing out the difference. So no, I don't share that part of the concern from JV, but in terms of highlighting, you know, this concern about common enterprise, yeah, of course. The SEC, and they're not doing a good job about it, as I'll highlight in a second, but yeah, they're absolutely bitching up a storm about Ripple's XRP sales. 100%. So JV's 100% correct on that. But let's dig into that. Attorney John Deaton shared the two-tweet thread from XRP community member JV that I just shared with you. And here's what Attorney John Deaton had to say about this. "This is no doubt one of the strongest general arguments the SEC has. More specifically, software sales compared to XRP sales to fund the business, etc." So pause to note, there's more than one way in which Ripple's business operations were funded, but I think it's pretty obvious based on Ripple's transparency dating back even before the lawsuit. Ripple would not be in the black if not for the XRP sales. And that's just a cold hard fact. We've been aware of that for years. Okay. But there were also software sales and there are other revenue streams, and okay, fine. And so John Deaton is pointing out this is perhaps the strongest general argument the SEC has. Fair enough. Okay. Now, it doesn't mean it's a good argument, and Attorney Deaton didn't say it was a good argument. In fact, he rips it to shreds here. So check this out. Here's what Attorney Deaton says. "But how does the evidence go to establish the common enterprise factor? What's the common enterprise? Incentivizing exchanges shows what?" I'm supposed to pause to note. When he says incentivizing exchanges shows what Attorney Deaton is referencing is that the SEC highlighted in this legal filing that Ripple was offering financial incentive for various cryptocurrency exchanges to list XRP. That's also not a secret. I knew that years ago, before the SEC v. Ripple lawsuit. And so again, Attorney Deaton says, what's the common enterprise? Incentivizing exchanges shows what? That Ripple wanted to sell XRP and create a secondary market? To accept this argument, the judge would have to find that the entire XRP ecosystem, including all XRP holders and all exchanges, are the common enterprise. That's what the SEC's Expert 1 claimed before the SEC abandoned him/her in part based on evidence presented by XRP holders and cited by Ripple. If Judge Torres is willing to accept that the entire XRP ecosystem is the common enterprise, then it may be proven to be correct. Yeah, so that's the thing, and this is why it's such a terrible argument on the behalf of the SEC. If memory serves, initially, SEC was arguing in line with the idea that Ripple is the common enterprise, but then they stopped pushing for that, and then it's the whole scheme, the entirety of it, the entire XRP ecosystem. Me, and yes, you listening to this room temperature jam right now, you are in a common enterprise, the SEC says, with a guy on the internet who currently goes by the name Moon Family Sedan. You're in, that's what there are. Well, they were arguing that anyway. And they had a paid expert known as Expert 1 who was claiming that. But then Expert 1 ended up getting dropped because after having information put in front of him, ended up saying, oh yeah, not so sure why XRP holders may have purchased the XRP that they purchased. And said, yeah, I need to look into that, which totally destroyed them as any sort of useful expert in the case. So the SEC dropped him because it was a bad argument. And so in terms of this common enterprise argument, Let's dig in a little bit further. I want to highlight, so here's the document. It was only 6 pages. There's only like 3 parts I want to highlight here. Starting with this point right here, there where I'm highlighting, which reads as follows. This is to Judge Torres from the pricks at the SEC. While certain of defendants' proposed redactions are appropriate to protect third parties' privacy and sensitive business information, as well as defendants' own sensitive business and financial information, many of the proposed redactions are too broad to overcome the presumption of public access. And I'll tell you, upon reading that, you know what I thought instantly? Oh, now you want the transparency. Every freaking thing possible wasn't in the public interest if it was from your side, but then the second it's not, oh, no, anything and everything. And they didn't literally argue anything and everything should be exposed, but it's just so funny how when it doesn't benefit them, like their entire thought process and approach to what should be public completely shifts. But that's just a minor point. Let's get into the bigger point here. Back to the bigger point here about common enterprise. The asshats at the SEC also wrote the following. This is page 2 now. Let me find the right spot. Yeah, starting right here. Reads as follows. They go so far as to seek to redact references linking Ripple's revenues with XRP sales. But this information is relevant to the court's decision on summary judgment because it evidences Ripple's reliance on XRP sales to fund its own operations and capital expenditures, and therefore demonstrates Ripple's common interest with XRP purchasers and the reasonable expectation of XRP purchasers that they would profit from Ripple's efforts. This information likewise supports the SEC's central argument that Ripple's XRP offerings closely resemble a traditional company's public capital raise governed by the requirements of Section 5. So what I wanted to note about this is that they wrote right in there, note that they wrote common interest and not common enterprise. The reason they wrote common interest and not common enterprise is because they haven't identified in this entire damn case, other than when they retracted their statement about Ripple, they haven't identified what the common enterprise is. And so they didn't write common enterprise there. They wrote common interest, and they're trying to conflate the two. But they are not the same. The Howey test is not about a common interest. It's about a common enterprise. Because otherwise, if there's just a common enterprise, it goes back to that whole argument that has been pointed out a number of times. Just like a company that uses gold in electronic devices, has a common, they have an interest in gold, but that doesn't mean that they're in part of a common enterprise with, a jewelry company that utilizes gold. They have a common interest in that they both like gold to continue to exist and be desirable for various reasons. There's a common interest there, but there is not a common enterprise there. And again, a common interest is not part of the freaking Howey test. And now we're at the end of the damn case, and they can't even type common enterprise because they didn't assert what the common enterprise is. So if this is their strongest argument, I'm sorry, it's a piss poor argument. It's not a damn good argument. It's an awful argument. And then go down a little bit lower here, they wrote the following. Another example of defendants' overly broad redactions of information relevant to the SEC's Howey argument is their request to redact the amount of compensation Ripple offered to certain trading platforms to list XRP. This information also evidences Howey's common enterprise and efforts of others prongs, and is therefore relevant to the summary judgment decision. That's what they wrote. Okay, yet again, the SEC does not state what the common enterprise is. So that's why I don't see how, if you're Judge Torres, you can allow this sweeping win for the SEC. I'm just not seeing it. They haven't satisfied. The SEC's arguments, they don't satisfy the Howey test. Even in the way they're arguing at this late stage of the game, they're saying common interest. What a bunch of asshat pricks. And so again, if this is the strongest argument, fine. It's pretty weak sauce. It is pretty weak sauce so far as I'm concerned. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.